28A. I will give you examples also how 28A has really worked. Please see this. After section 28, the following section shall be inserted. Notwithstanding anything contained in this code or any other law for the time being in force, where a creditor of the corporate debtor has taken possession of an asset of a personal guarantor or corporate guarantor of the corporate debtor by enforcing its security interest over such asset under any law for the time being in force. Read it as Surface Act for the time being, which empowers the creditor to transfer the asset. The creditor may, during the corporate insolvency resolution process of the CD. So we remember CD is balance sheet, CD is assets which are different from personal guarantor, corporate guarantor, his assets, her assets, its assets outside the balance sheet of CD. You have to imagine that. Parallelly, while CD is undergoing CARP, the creditor has invoked the guarantee or filed a case against the or put under auction the properties of the individual personal guarantor or corporate guarantor. In that scenario, the creditor may, during the CARP, transfer the asset with the approval of the COC as an asset as part of the insolvency resolution of the CD. That is the beauty. Now, where the corporate guarantor is also undergoing CARP or liquidation, transfer the asset under this section shall take place upon approval of the COC of that CD also. Corporate guarantor is a CD. And where there is a personal guarantor, individual, his asset is going to be sold, that can also be brought here. Creditor may transfer that asset. This provision 28A is very, very interesting, requires little bit of technical reading of the provision. I will tell you some instances so that we understand what is the reason for introducing such provision and what is the thought process. Let me give you the example of a company's case where the financial creditor, armed with collateral security as well as personal guarantee, corporate guarantee, and so many securities. Normally we used to say, whenever you want to get loan, we used to say, the financial creditor may be the bank. You ask the promoter, borrower, director to sign. He will sign anywhere with the common seal. You ask him to put signature and common seal on the shirt, he will do it. When it is borrowing. So when all the assets or security coverage is created, the bank will be in a comfortable position because the security coverage is very high. Even if the borrower's business fails, there is no problem for the debt. It will not be a loss asset under the IRAC norms, that is income recognition asset classification norms, prudential norms. Now in this case, all assets of the individuals are sold. They were also sold in the auction and good money is recovered. Ultimately a few lakhs is due as against 32 crores claim. And still, it will not be possible to come out of the CARP because of the nature of provisions that operate. This is one scenario. You see, you have to carefully apply your mind on scenario so that you understand what is the purpose of 28A. The second is a scenario where a live case is only I am saying. The corporate debtor's asset is actually surrounded by like the Strait of Hormuz, entirely by personal assets. It is as if without acquiring the personal asset, you can't even reach the corporate debtor's asset. Now, if you are the liquidator, how will you ever bring a sale of the corporate debtor's property? Because it is surrounded by individual assets. At the time of lending, the banks have approved it. They have not bothered. They didn't worry about the complicated scenario of the corporate debtor's asset as a standalone basis can never be sold unless there is at least somebody who is buying should have a way. It's an industrial property and somebody cannot just barge into and trespass upon the personal property of the individuals to enter into the asset under sale in auction in liquidation. Scenario number 2, kindly imagine this. Scenario number 3 is very, very interesting. I hope you are all carefully listening to the scenario. This is a very interesting scenario. Here is a case where the land is completely held by the individual. On the balance sheet, only the building and plant and machinery is there. Actual scenario I am saying. Now, so far as the corporate debtor is concerned, under the IBC framework, a resolution professional is running the CARP. And so far as the individual personal guarantor is concerned, there is somebody else is appointed under the Section 95 proceeding as a resolution professional for the individual. And that repayment plan also fails. Thereafter, 123 starts. Bankruptcy is initiated. How will this liquidator, here it has become liquidation, there it has become bankruptcy. Bankruptcy trustee, liquidator, both of them have to put together all their properties. And whole lot of asset, land, buildings, plant and machinery, if it is put on sale, some value is possible, value maximization is possible. Now, if I have to buy only the land, what will I do with the land and plant and machinery? If I have to buy only the land and plant and machinery and buildings which is on the balance sheet of the CD, what will I do for the land? This kind of scenario is a very interesting scenario. In fact, there is one more case, scenario 4, not directly connected with 28A, is where I am still arguing this matter, where the land and building is sold by the bank to somebody under Sarfasi, but plant and machinery is intricately intertwined in the building itself, electricals, everything. Nothing can be removed unless building is damaged. But land and building is sold already. Only the plant and machinery is under CARP. Different scenarios are created. Difficulties are created. So 28A brings for the first time a scenario where there could be possibility of personal asset or asset of the corporate debtor transferred to the CARP. As a whole, it can be sold and there could be value maximization. Because a joint auction by a bankruptcy trustee and a liquidator of the CD is never heard of. Such a scenario is not seen. And NCLAT, NCLT and across the country, different benches, different circumstances, different kinds of, we can say, cocktail or mocktail will be done. And therefore, 28A has been introduced to bring some sort of discipline. And yet, it is only an enabling provision. It's not a mandatory provision. It is only to meet exigencies, such sort of thing. Because strategically, when you are borrowing itself, a smart borrower puts these kind of hindrances, keeps the assets registered in personal name and keeps some other assets registered in the name of the corporate. And when it comes to enforcement of security interest, this kind of entanglement takes place. People are going to be in difficulty. So therefore, 28A is, in my opinion, a progressive legislation introduced for the first time, gaining from the experiences which I have explained to you. Actual experiences we have experienced, which means across the country, how many such experiences would have come? This is the fourth point I thought I will give you, and you may want to read further. You please read para number 17.6 of the report of the committee. Prior to going with the Amendment Act, there was a long deliberation. Suggestions were asked from various stakeholders, and the ministry responded it. Finally, the committee approved a particular amendment. 17.6 paragraph you read. It will be very useful.